I'm Mario Correa, wills and trust attorney, and one of the questions that come up every once in a while is, can a spouse disinherit another spouse? And under Illinois law, the answer is maybe. The reason it's maybe is back in about 40 years ago, there was a case called LaGrange that our Illinois Supreme Court held that a spousal election didn't apply to a joint asset. What that means basically in English is a spousal election is the right of a spouse to inherit under a spouse's will, even if they're not named in that will. So what Illinois law says is if your spouse doesn't include you in the will, you as a surviving spouse can demand 1/3. Well, that's the rule to protect the spouse. However, if it's a joint asset, that asset passes outside of probate, and what LaGrange held was since it was outside of probate, the spousal election did not apply. Since then, there's been a lot more trusts that have been created, a lot more ways of transferring assets outside of probate. And in a much more recent case, the Supreme Court held in a case involving Rush Hospital and a donee, that the donee had made a pledge to Rush Hospital and then had second thoughts about that pledge prior to death because of apparently some kind of outcome that they had hoped wouldn't happen. So they tried to undo it by using a living trust. And the court in that case held that it was a fraudulent conveyance and could go after assets outside the probate estate. Whether that second Supreme Court case effectively overruled LaGrange is unclear. So the law is unclear as it is. The only way to protect yourself as a spouse is to make sure you're on title. That's the best way to protect yourself and own some of those assets in your name or in joint names with you as the spouse. Otherwise, you're exposing yourself to clarifying this law, and that's not where you'd like to be. So if you have further questions, please give me, Mario Correa, a call at 773-489-8500.